If you want to look for fault, look in the mirror.
Yeah.
Because we've all done this. And by not knowing certain things, and here I'm talking specifically, what I'm holding up in my hand is what you call rule of law, UK and Australia. Now what I've got here is your Queensland Constitution. I've got your Commonwealth Constitution. I've got the Australia Act. And I've got the Oath of Allegiance for the High Court Act. And I've got the Scriptures. Now I'll show you why they're all integrated. Now what we've done in Australia is essentially, by not paying attention to this what you call rule of law, things have got out of hand. Now the only reason I load the criminal charges is to bring an accountability. It's not to send people to jail. That won't happen. The system won't permit it to happen. But the system, if you handle it correctly, and with a great deal of maturity, because this is the biggest issue that's ever hit this country, it's yet to hit. But if you don't handle it correctly, you'll wish you had handled it correctly. Can I make that point? That's why it's not what you call a radical issue. It's one of people at the bar table, and they don't need what you call the rented crowds of everyone's agenda finding a self-purpose. I think I'm quite clear in what I'm saying there. What this needs is a great deal of understanding with a great deal of compassion. Because the people who are going to get hit with this really have no idea of what they've done wrong. Now you'd say, and could say, well, they should have known. Well, that's fair. But when you start walking into these offices, handing these charges to them, the look of unbelief and disbelief on their face, which is astronomical. Now what I'm going to do is show you a few things in relation to what should have been done. Now the reason why I laid the charges is because you cannot activate Section 80 of the Commonwealth Constitution, and I'll read that. Please go home and get one of these. Now if you haven't got one, download it somewhere, but start looking at your Constitution. But Section 80 of the Constitution states this: the trial on indictment of any offence against any law of the Commonwealth shall be by jury. Now I'll read that again. The trial on indictment of any offence against any law of the Commonwealth shall be by jury. That is your constitutional right. Now I know that courts have been blocking it for this reason. You didn't have an indictment. Most people will not understand, if they're not legally trained, what an indictment is. Section 80 only operates when you've got an indictment in your pocket. That's the whole point of laying the criminal charges, which I'll explain in a minute. And every such trial shall be held in the state where the offence was committed. And if the offence was not committed with any state, the trial shall be held at such place and places that the Parliament prescribes. This is your Queensland Constitution. Now it says, irrespective of all the changes and amendments, forget that. It says Constitution Act 1867, Queensland. I assume a lot of you will start looking at this now, because that's been the problem. You've let other people look after your law without understanding, excuse the expression, they're tickling the till. Now the till's got shut. But in this in your Constitution, it says this. At Section 53, it says requirement for referendum. Now, do you all know that's in here? You do now. And I'll tell you what the requirement is. A bill that expressly or implicitly provides for the abolition of or alteration in the office of Governor, or that expressly or implicitly anyway affects any of the following sections of this Act, namely Sections 1, 2, 2A, 11A, 11B and section 753. Shall not be presented for assent by or in the name of the Queen unless it has first been approved by the electors. You didn't see a lot of this. I'll tell you why. Because the really shifty, you know what a group of lawyers do. A group of lawyers all get together to work out how to get around all this. They don't get together to be honest. Let's be straight. Here's a farmer calling the lawyers dishonest. I wonder why. But at section 53 subsection 5 it says this: any person entitled to vote at a general election of members of the Legislative Assembly is entitled to bring proceedings in the Supreme Court for a declaration, injunction or other remedy to enforce the provisions of this section. Now, what they do is they say, we know it will require a referendum, but we're not going to do that. We'll wait and see who issues a writ in the Supreme Court, and then we'll strike the writ out. Now, the moment they strike the writ out, you're in a cost order situation and you've got to go into appeal. They make it look like an automatic right, but just take them on, and you'll know what I mean. What they should have done is obeyed the referendum requirement. So what they're doing is bypassing that. They won't do it anymore now because they're caught now. Now listen to what it says. At section 53 subsection 1. Shall not be presented for assent by or in the name of the Queen unless it has first been approved by the electors in accordance with this section. And a bill so assented to consequent upon its presentation in contravention of this subsection shall be of no effect as an act. I'll read that last bit. It says it shall be of no effect as an act. That means if it was due to come to you and you never got it, the legislation created, they may as well shred it. Got that? Unless you do nothing. They'll keep it. But it's actually what they're doing is keeping a piece of paper that's not worth the paper it's written on. That's what it says here. Why? Because they didn't bring it to the people. Now look what they did with the Australia Act. So the next one is the Constitution and the Australia Act, and I'll deal specifically with section 13 of the Australia Act. 13 of the Australia Act states this: Amendment of Constitution Act of Queensland. Do you love that? And look at the two sections they amend. Section 11A and Section 11B. The problem is, they're two of the six that's in here. What just happened to the Australia Act? Beg your pardon? It's just, you've just made it invalid. Now the courts will hold their seat and try to sort of say, we'll ride it out. But if just this number of people turn up in a courtroom, the court knows it's got to give up. Do you understand that? Because it's all over for them. I'll tell you why. This is the High Court Act of Australia. Now this is not a matter you take anywhere near the High Court, because it's there to donkey drop you. I can say that quite clearly. Because it will. If you let it. In the High Court Act, section 11 is the oath of allegiance. A person who is appointed as a justice after the commencement of this act shall, before proceeding to discharge the duties of his oath or office, take an oath or make an affirmation in accordance with the form in the schedule. So when you go to the schedule says this. This is for the High Court judges. Now I'll say, your Chief Justice is a guy called French now, so I'll say French. I, certain Justice French, do swear that I will bear true allegiance to Her Majesty Queen Elizabeth II, her heirs and successors according to law, that I will well and truly serve her in the office of Chief Justice of the High Court of Australia, and that I will do right to the manner of people according to law without fear or favour, so help me God.